Hello, fine people of YouTube. I'm Vince White. I'm an employment attorney, and we are answering public posted questions from YouTube users, trying to get folks the answers they need from an employment attorney. Because let's face it, employment attorneys are a little stingy with the answers. Everybody wants to get paid for their help. It's a little foolish. You help 20 people, you get one case. And that's not what I'm doing here. I'm not trying to get cases, generally speaking. But I just think we should help more. Okay, so we have YouTube user Jay Hefner teaming up. This is a combo question. 2 longtime viewers of the channel. Jay Hefner seems to have teamed up with Charles Johnstone. They asked their various questions 1 month ago on our video entitled, "Is it to an attorney's advantage to prove when witnesses are lying?" Generally, yeah. Okay, so Jay Hefner started things off by asking, good video, sparks a question. That's what I'm here for, man. After both sides have completed depositions, what strengths or weaknesses determine the value of the case? Does the size of the organization matter? And when threatening media be an effective tool to get a stronger settlement? Okay. I'm going to go on and read Charles Johnstone's component of that question. He commented underneath. "This is a good question, Mr. Hefner. I am in the same boat. My employer is a very large one in the healthcare industry, and they tried to get me to sign a 13-page non-disclosure agreement in exchange for 6 weeks' pay. I refused. They are terrified about bad media. I am ruthless, though, and I have threatened to go public at the right time. I am a win-at-all-costs type of guy, but Vincent seems like a good guy. Thank you. So I'll be interested in what he has to say." Okay. So I'm going to kind of go through and pick the questions apart because there's a couple different questions here. What strengths and weaknesses determine the value of a case? I have a bunch of videos on case valuation on the channel that I'd recommend you listen to. Once you value the case, you need to sit down and ask yourself very seriously, very brutally, knowing the evidence I have, what is the likelihood that I can prove this case? And just for the easiest tool, the easiest shorthand guesswork process that I can recommend here. Like, let's just say you think your case is a value of $100,000. Not saying, just a hypothetical, just easy math, 100,000, right? And if you think you win your trial 60% of the time, then you might want to be thinking about, well, do I hedge risk? Do I make a demand for 60% of the value? If it's worth 100,000, if I win, potentially, you don't know, but that's what you think it's worth. That's what you calculated it's worth. And I think I only win 60% of the time. Do I want to make a demand for 60,000? Right? These are the questions you ask yourself. So that is a really quick shorthand way to address that question. You go on to ask, does the size of the organization matter? Yes, to an extent. It matters in 2 ways. One, it matters in terms of what laws apply to it. Right? It has to be big enough that various sets of laws would be applicable. There can be an employer that's so small that very few laws apply to them. That is a meaningful difference in terms of the size of the organization. The second way it matters is this. If you think you've got yourself a huge case, right? You think, even not a huge case, maybe you just think your case is worth $300,000. But you're pretty sure that company doesn't have $300,000. They just don't have that kind of assets. And cue the commenters like, all companies have $300,000. False. You're a moron. You don't know anything about business. There are many, many employers that just don't have $300,000. There are many employers that are deeply in debt and really don't have much in the way of assets. That's a reality, right? And I don't need your Reddit anti-work. No, all employers are wealthy. Rise up. Shut up. You're a moron. You just understand nothing, okay? What you're looking at here, in terms of the size of the organization, is can they pay? Right? They can't settle with you if you're asking for more than they have. And if you win at the hearing and it's more than they can pay, they're just going to go bankrupt. This is fairly simplistic, right? Like, this is, if you win billion $2 and the company has $5, you're going to get $5, if anything, right? It's that simple. So the size of the organization matters in those ways. Now, the third part of your question, which I think Charles Johnstone was kind of touching upon as well, is would threatening media be an effective tool to get a stronger settlement? And here's what I'll say. Don't threaten. Generally avoid threatening media in an if this, then that way. If you don't give me X amount of dollars, I'm talking to the press, is a very bad idea. Don't make that direct statement for a variety of reasons. And part of what you're facing here, one of the difficulties you're facing as a pro se litigant, I think you're unrepresented, is that your attorney can't have a reputation for controlling the narrative in the public eye, right? If someone's litigating with our firm, they pretty much know that we take pains to control the public narrative and protect our client, right? We're not threatening press. We're not saying give us money or we'll do press. That's not what we're engaged in. We're engaged in there's a public narrative about these incidences and we need to control that narrative to protect our client in terms of their future, right? In that process, the employer can be greatly harmed. And many employers will be aware of that and they'll know what we do and they'll look at the press page for our firm and they'll be like, oh, Lord, these are attorneys who, really control the public narrative. They work with talented professionals who do that. We should look at settling, right? And so certainly we're never in a position where we'd want to say, give us the money or else we'll talk to the press, right? That's not something you want to engage in. But you don't have that because I think you're pro se. So you might want to, if you're speaking with a reporter, talk about that. Listen, you're talking to defense counsel and you're saying, guy, I got reporters calling me and I don't want to talk to them. So are we something going to happen here or not? Right? I don't want to call these people back. You're not threatening. But the fact of the matter is people are interested in your case and reporters are going to report on it one way or the other if you file it in a public docket like state or federal court. So, you got to speak with them just for the interest of controlling that narrative, protecting yourself. And the fact of the matter is the case is going to have to get filed in the public docket eventually if it doesn't settle or it doesn't go to hearing in an agency. So, that is a useful conversation to have. Don't overvalue that. There's a lot of people who sue big companies, like people who sue the MTA. I'm going to go to the reporters. I'm going to go to the press. My friend, the MTA is one of the most universally hated organizations in the entirety of New York State. You can't make them be hated more. They've ruined countless lives, killed thousands, openly discriminate against their own employees, treat people like garbage, and actively harm New York City while allegedly pocketing money that they could have and should have used to update our commuter system, right? They don't care. They don't care about your allegations of hate crimes. The MTA's response is yeah, that was a good one. Generally speaking, right? It's a nefarious organization. And many employers are going to be like that. Right? Many employers are just going to be like, that person's a liar. And that's it. That's their whole response. They just don't care, right? So yes, doing press can have real value if it's done properly. But don't overvalue it. Because one, it can only be done once, right? Like you can do more than one press, but once you do press is out. You can't put the genie back in the bottle. So the employer's not going to like have an impetus to think about that. Once press is done, what's done is done. It can't be undone, right? And then just two, many employers just don't care about bad press all that much. So be aware of that. Yeah, I think that's my answer here. I hope this is helpful. If you have follow-up questions, I will track the comments down below, and I will try to give you better, quicker answers. If this was helpful, like and subscribe. Helps me to help more people just like you. Take care.